Good morning, good afternoon, good evening to wherever you're logging in the world. Thank you for joining us for this webinar update on the new BVI trust and estates legislation. My name is Henry Mander. I am the Global Head of Private Wealth at Harneys. And today I'm joined by Matthew Howson, who's a Senior Associate based in our London office.
Yes, so hello everyone. I'm greeting you from recently unlocked down London, so we're all in an excellent mood here. As well as trusts, I assist Henry with BVI probates and wills, so I'm looking forward to talking about that with you later on.
Great, thank you very much, Matthew. So just going on to a contents page of what we're going to run through today. So we've tried to break down the analysis of the legislation into three parts so that it's not overly just going through the black letter law word by word, and instead trying to apply it to explain how it will affect and enhance the options and the way BVI trusts are dealt with. So the first section will be about trust structuring, and it's largely about the extension of the express powers that are able to be reserved under BVI trusts, and I'll give a little analysis of how that the new reserve power legislation interacts with Vista, and I'll give a very short refresher on Vista. We'll then jump into the second section, which is about trust administration, where we're going to cover four new areas of the law fairly quickly. We're going to canter through those, but just to give you a flavour of what's changed. And then the third section is largely on estate administration, so where probate or letters of administration, grant of representation is required in BVI, how that is dealt with and what's new in those fields. So starting then, please, with the trust structuring. So I'll just give a brief history of why reserve powers have come into existence, why they are popular, why there was demand for them in BVI. And it goes back to the very notion of the fact that BVI trusts are used by clients all over the world, whether they're in common law or civil law jurisdictions. And certainly some decades ago, when explaining to high net worth individuals in certain parts of the world about the option of a BVI trust, I think two things that became difficult to sort of negotiate with a potential settlor was, firstly, that he'd have to transfer legal title of all his hard-earned wealth to a trustee, so he would no longer own it. But secondly, the trustee would then own duties not to him, but to the beneficiaries. So there was a sort of double leap of faith that was required. And I think so reserve powers legislation was introduced by the vast majority of the IFCs, I think initially as a way of allowing settlors and people trusted by the settlor to keep control, not only to clients in civil law jurisdictions, otherwise where there was, you know, the development of the Office of the Protector, and I'll get to that specifically in a minute, but sort of just a sort of liaison or a check and balance on the trustee, or any, you know, vary from trust to trust, but just a way of interaction between the beneficiaries and the trustee, and certainly that's how reserve powers became appealing, because there was the notion of the classic trust and all the benefits of succession planning and asset protection, but potentially with the ability to reserve extensive powers to a settlor. So BVI was arguably the first jurisdiction to introduce any concept of reserve power trusts, and what it did was in the old section 86, which was titled Protector of Trusts, and it did list certain powers that are commonly reserved away from trustees, but it was a non-exhaustive list. So it sort of said, you know, it left to the imagination other things that could be reserved away from trustees, and indeed were very commonly. But the list of the express powers that were cited in the law were relatively conservative. They were such as the power to change trustees, the power to change governing law, power to change beneficiaries, things that we don't really think of nowadays as reserve powers. Those are just things that a settlor or protector might easily have vested in them. Whereas now, the new section 86, I think just from its title, you can see the way that the sort of the express nature of the legislation is going. It's titled Reservation or Grant of Powers to Settle or Others. And so what's happened is that a statutory presumption has been created that, notwithstanding the reservation of certain, now a longer list of express list of powers, notwithstanding the reservation of those powers away from the trustee, that will not invalidate the trust, prevent the trust from taking effect, or cause any of the trust property to form part of the settlor's estate. It's all about the interaction of reserve powers while still ensuring that the three certainties are satisfied for the valid constitution of a BVI trust. If you then look at the express list of powers that are in the new Section 86, it does include those that I listed that were in the old Section 86, such as changing trustees, change of governing law, but it's now much more extensive in terms of the types of powers that you could see reserved away from trustee that are expressly listed. And I'll underline the point that these were always able to be reserved away. It's just that they were not expressly listed in the legislation. So this will give comfort to the draftsman, will give comfort to trustees. And they include the power to direct distributions, so a settlor can direct the trustee as to distributions of capital or income, a power to direct the appointment of directors of holdcos. That's a bit of an overlap with Vista that I'll get to later. And then also a power to direct the trustee as to purchase or sale of trust assets. So it's a more extensive express list of powers that are reserved away. And the good thing about this is that the legislation applies to all BVI trusts. It's irrelevant as to when the trust was constituted. So even if you have a trust that's created in the 1980s that has a power of amendment, you can now introduce reserve powers and benefit from the comfort of having this expressly in the law. I think my final point before I talk about Vista Trust will be just about the evolution of the use of reserve power trusts. And I spoke about why they were introduced. And I think, you know, that was in a different era of offshore planning where I think there was less sophistication, there was less understanding of trusts by advisors in civil law jurisdictions. So I think the notion was very much, let's reserve everything away from the trustee that we can within the law. And of course, doing that does open, well, it certainly affects the asset protection benefits of the trust. It can open the trust make the trust more open to attack by creditors or settlers. I'll talk about the BVI firewall and changes to that shortly. But I think we're now in an era of the appropriate use of reserve powers. I mean, trusts have become increasingly complex. The wealth that's being held in them is a lot more. The time it takes to create a bespoke trust, and I think that's appreciated by clients and the team of advisors, both onshore and offshore, that it's really about taking time, measuring twice, 3 times, and cutting once to make sure you really have the right trust with sufficient flexibility, but also the correct, appropriate allocation of responsibilities and duties between power holders. And that's not just, okay, saying I've got the trustee and the settlor, let's give the settlor as much as possible. It's a much more delicate balancing act. We've had case law going back to 2011, the TMSF and Merrill Lynch case that was a Cayman case that went to the Privy Council in London, where ultimately it was found that a power of revocation was tantamount to property and could be excised by creditors of a settlor. And so we have moved into a different era in the last decade where you have to be very careful with reserve powers. Yes, they are available under the law, but you don't want to reserve everything away because you really will undermine the integrity of the trust. Post Pugachev, I think, you know, we've got to be careful about what is not conferred on the trustee. And by that, I mean more use of fiduciary powers rather than personal powers. Giving personal powers to a settlor will detract from the integrity of the trust. Instead, if you can have appropriate power holders, whether that's a protector committee, investment committee, whatever kind of committee, you can give them. And it may well be the case that it's more appropriate for them to have investment responsibility than the trustee, given the rather quirky nature of the assets in the trust particularly. But they've got to be well drafted, bespoke, and with detailed analysis with onshore lawyers to ensure that they work in the countries where the assets are and where the beneficiaries are. But that's just really sort of some commentary on the evolution of reserve power trusts. The fact that the BVI has strengthened its legislation in this area is very good. But we still, whenever introducing excess or more than standard powers that are reserved away from the trustee. You have to be very critical about how that will work in the life of the trust. Then just moving on to Vista, because I don't think you can talk about reserve powers in the BVI context without talking about Vista. And I'll just give a very short recap on Vista for those who have not dealt with it recently. So it stands for the Virgin Islands Virgin Islands Special Trust Act, came into force in 2004 with some fairly major amendments 10 years later in 2013. And the essential features of Vista are that it is designed for trusts that own BVI company shares. And those shares can obviously own any assets underneath. And what it seeks to do is effectively allow for some form of reserve power as regards the investment responsibilities of the trust. So it ensures that the trustee holds the assets on trusts to retain rather than trusts for sale, and prevents the trustee from taking its usual shareholder actions in relation to the trust, unless in extreme circumstances, which can be drafted in the trust deed. And I think the reason why there was no need to sort of expressly extend the reserve power legislation in BVI until now is because Vista really covered the main power that people seek to reserve, which is the power over investments. And this is often where there is the clash between the trustee and the settlor, because the trustee by its very nature will need to be conservative about safeguarding value and the types of assets held in the trust, whereas settlors may have made money through entrepreneurial flair and have a different risk tolerance towards investment. So that's where Vista was introduced. And it required a BVI company to be placed as the holding company in the trust. And initially, the sole trustee had to be a BVI licensed trust company. That's now been extended to say that one of the trustees must be a BVI licensed trust company or a BVI PTC. The vast majority of Vista trusts we see still have the sole trustee as being a BVI licensed trust company, but there is more flexibility now. In terms of a modern application of Vista, it's much more the case that people now, and we've worked on a number of more complicated applications so that, for example, Vista can apply at certain points during the life of the trust. You might have a very straightforward trust where it's really a will replacement device that seeks to replicate the testamentary capacity that we understand under common law, so that the trust is established as a Vista trust, so that the settlor as director of the underlying company can retain control over how the company is run during his lifetime. But then the trust is terminated on his death with absolute appointments or absolute entitlements passing to chosen remaindermen. So it's nothing more than a will replacement device, but it ensures that you choose who is to benefit on your death. And then there are what we call a toggle or trigger device, whereby a trust can start off as Vista or non-Vista, and then change from one to the other. For example, a settlor, again, may want to keep control during his lifetime of how a company is run, but then on his death, he would want the trust to become a fully managed trust in the classical sense, with the trustee having all its oversight duties over the company. And that's where Vista may be disapplied on his death. So there's a number of different ways of doing it. And we've worked with trust companies and lawyers internationally to really make bespoke structures using the Vista regime. And then just commentary on the interaction of reserve powers trusts and Vista. I think importantly, Vista really just deals with administrative powers in the sense of investment responsibilities, whereas when looking at the wider reserve power trust regime, you want to be looking at dispositive powers, such as the powers to make distributions, the power to change beneficiaries, change trustees, and whether that's giving those powers to a protector outright or just requiring protector consent. There needs to be both an application of the Vista regime and use of reserve powers. So I think now, again, with the theme of modern trust planning in the BVI, where there are bespoke structures looking at different types of when to apply Vista, but also now the combination of how one can use the extended express list of powers in the BVI legislation, you can create a really bespoke structure that works for the clients both offshore and onshore. So then moving on to our next section, which is on trust administration, Matthew is just going to give an update on issues to do with mistake.
Thank you, Henry, and sorry for that. A doorbell is never a quiet moment in London. I'm going to take you through what is known as the old rule in Hastings Bass. I won't take you through all the history of the case law, which I can assure you has been the subject of many fascinating trust law seminars, but basically it concerns the situation where you're a trustee or a power holder and you exercised a power. Say you made a distribution to a beneficiary, and that exercise turns out to be disastrous. Perhaps you were negligent and didn't bother to check the tax consequences of doing so, or perhaps you took proper advice, but that advice was itself negligent and wrong. Under what is known as the old rule in Hastings Bass, the court could assist a trustee by agreeing to set that exercise aside as if it had never happened. This happy state of affairs continued to 2013 in the cases of Pitt and Holt and Futter and Futter. In those cases, the UK Supreme Court decided the rule in Hastings Bass had gone too far. They said it should not be possible to roll back transactions where the trustee had not made any breach of trust and had properly obtained advice, which turned out to be wrong advice. Instead, the court thought in that situation, the more appropriate recourse is for the beneficiary to sue the trustee or advisor for breach of trust or negligence as appropriate. Not surprisingly, this was not popular with trustees or advisors or even beneficiaries because of the cost and hassle involved in a further unpleasant court process. It also seems rather unfair because a lot of these cases turn on evolving tax law where the advisor had taken what seemed a perfectly reasonable interpretation of the then tax legislation. However, because it was the UK Supreme Court, the only way the decision could be overturned was by statute. And so the BVI government has now stepped in to essentially bring back the old rule in Hastings Bass. The new legislation will most likely state, once passed into law, that as long as certain requirements are met, the court can set aside the exercise of a power, either partly or wholly, and on such terms and conditions as it thinks appropriate. The requirements are that, you can see them on the screen, but in summary, in the exercise of the power holder did not take into account one or more relevant considerations of fact, law, or both, or took into account one or more irrelevant considerations, and that if it were not for this, the power holder would not have exercised the power, or would have exercised the power at a different time or in a different manner. Note that no breach of duty needs to be made out, and that, as per the slide, a very wide variety of people can apply. Back to you, Henry.
Thank you very much, Matthew. And so moving on to the firewall legislation, and one thing I did omit to mention earlier is obviously we have the question function on Zoom. So if there are any questions, please do raise them when you think of them, and if we can, we will answer them either during the content of the webinar or at the end. I think this comes down to a brief analysis of the history and the application of the firewall. When you choose BVI law as the governing law for a trust, that's a decision that the trustee and settlor come to together, and essentially that means that the BVI court, for the vast majority of issues to do with the trust, will have sole jurisdiction to deal with any questions to do with the trust and how it's administered once it's been validly established. And I think we need to just consider that invariably there will be a conflict of laws where BVI trusts are concerned, because the assets of the trust may well be outside the BVI. The settlor is highly likely to be outside the BVI, as are the beneficiaries. There are clients all over the world that will be having a connection with BVI trusts. So the purpose of the firewall and the reason why it was introduced is such that the jurisdiction of the BVI court and the application of BVI law is preserved, to the extent that where a foreign judgment, so the judgment of a foreign court which seeks to devolve the assets of the trust in a way is not in line with the trust instrument, that judgment will be unenforceable in the BVI. And instead, of course, the assets will pass in line with BVI law or in line with the terms of the trust instrument. But such judgments of the foreign court usually arise from either forced heirship claims of disgruntled beneficiaries, and just to recap, in civil law jurisdictions, the concept of testamentary freedom is not there, to the extent that there is typically a requirement that a certain part of an individual's estate will have to pass to certain prescribed beneficiaries in that jurisdiction. And by no means are civil law regimes similar. They vary hugely within the Sharia world to what is in LATAM, to what is in Russia. But essentially, there is generally a concept that you do not have 100% choice to decide where your assets pass. So invariably, disgruntled beneficiaries, where a trust has been set up in lifetime, may well obtain a court order to ensure that in that jurisdiction, the assets, the part of the estate that should have passed to them, had the trust not been set up, should indeed pass to them. The other type of court order that comes about would typically arise from a divorce, from where the assets of the trust are essentially a part of the matrimonial assets for the purpose of the division of those assets on the divorce. So those claims typically result from the fact where the claimant or to the foreign court order had what was a personal relationship with, historically, the settlor of the trust. And it's that definition of personal relationship which is crucial, because what the Section 83A, which has been updated in terms of the way that the defined term personal relationship is set out, but Section 83A has been updated to ensure that the foundation was that those types of judgments would not be enforceable in the BVI to the extent that they conflicted with the devolution of the assets in line with BVI law or the trust instrument. So the update to Section 83A has done two things. Firstly, it's modernized the definition of personal relationship to take into account more modern forms of relationship between individuals and a settlor. For example, surrogate children born through IVF, etc. And it's extended to cover all manner of modern relationships, which the old definition hadn't picked up in the previous 15 years. Additionally, the personal relationship can now be with a beneficiary of a trust as well as the settlor, so that where a foreign court order arises due to the relationship between an individual and a beneficiary, that will equally benefit from the firewall in the way that a claim against arising from a personal relationship with a settlor. Additionally, section 12 or subsection 12 of 83A, which is the real meat of the firewall and provides for the unenforceability of certain judgments when they seek to alter various aspects of BVI trust, that has updated the references to trustee, historically trustee, to extend to a term called office holder. And the term office holder is defined to mean trustee, protector, anyone else who has powers in the trust. And I think, again, that goes along with what I was saying earlier about how the reserve power trusts, the application of those and the more sophisticated use of them has expanded over time. And so the firewall equally had to be extended to note that it's not only the trustee that may be affected by the foreign judgments. It may well be the protector. It may well be other committees of power holders within the trust. So they are now all within the defined term that can benefit from the application of the firewall. So that was a real canter through it. If there are any other questions, you can raise them on the chat, or indeed email either Matthew or me with our details after the session. So the third aspect of the trust administration I want to talk about quickly is variations of trust by the BVI court. So what's been introduced in section 58B is, for the first time, the ability for the BVI court to order variations to a trust, to a BVI trust, without the consent of the adult beneficiaries. And this obviously is an issue where an adult beneficiary might say, well, that's not good, I'd like to consent. So there's two aspects to it. The reason for the introduction is that in certain onshore jurisdiction, in certain onshore jurisdictions, the requirement to consent of an adult beneficiary may itself be deemed to be property or dealing with property in a way that could cause or may cause a taxable event in that jurisdiction. And we've seen this especially in the States. So it has been difficult for trustees to get variations of trusts achieved without which require the consent of the adult beneficiaries, which then themselves cause tax consequences. So there are other jurisdictions that have had this. So it's very advantageous that BVI has now introduced this, so that you can make these changes without requiring the consent of adult beneficiaries, which could then cause adverse tax consequences in their countries of residence or domicile. On the other side of the coin, there are extensive safeguards to ensure that obviously beneficiaries are not negatively affected by any such variations. Of course, trustees have got duties to beneficiaries to ensure they're always acting in their best interests, and many of the safeguards rely on the wishes of the settlor or require the consent of the settlor, etc. The way that the regime is introduced is that it's an opt-in regime, and this applies only for new trusts. So unlike the reserve power legislation, which is retrospective and in my mind just an extension of what the law was originally, this is a new regime that requires you to opt in, which can either be done in the trust instrument itself or in a deed which changes the law of the trust to BVI. And so I'd just like to add some commentary on a powers of amendment in relation to this as well, because whilst obviously sometimes going to court for the court to order the variation is the only option, it's worth noting that most modern trust instruments governed by BVI law will have wide in scope powers of amendment, and those powers of amendment may be vested in the trustee, they may be vested in the protector or the settlor, but typically you would be able to achieve most of the amendments you need to a trust via an exercise of the power of amendment. And I think what goes in line with that is the evolution of case law as regards how wide in scope powers of amendment are. And there's no direct BVI case law on it, but certainly persuasive case law from the UK and other common law jurisdictions, by which I think the very notion that a few decades ago that a power of amendment was only as wide in scope as could have reasonably been anticipated by the parties to the trust when it was created. So pretty narrow, to an extent where the case law now has acknowledged that really the power of amendment should live and breathe with the substratum of the trust as it evolves, to the extent that the scope of the power of amendment should be what is in the reasonable expectations of the parties to the trust at the time when the power is sought to be exercised. And so that gives it a wider sort of scope simply by the evolution of case law over time. But I just wanted to point out section 89 of the BVI Trustee Act, which is a very often overlooked section, which is titled Construction of Powers to Amend Trusts. And it says, and this is not a new section, this has been in the law since 2004. It says, in the absence of any contrary provisions in the trust instrument, an express power to amend in a trust instrument shall be construed as a power to vary all or any of its terms, including terms implied by law. So I think whilst this variation by the court without the consent of adult beneficiaries is useful and certainly an opt-in that we can look at for new trusts, the takeaway point I would say is that most modern BVI trusts have wide in scope powers of amendment. We are now in an era where case law has determined that powers of amendment can be taken into account as to the time at which they are sought to be exercised. So what is in the mind of the trustees, what the trust is looking like at that time. But you also have the express legislation in section 89, which says you can construe a power of amendment to include the ability to amend any term of a trust instrument unless there is a contrary provision in the trust instrument. So I think the takeaway is that powers of amendment are wide and can be widely exercised to ensure sufficient flexibility over time. So moving on to our last section in the trust administration, to Matthew, please.
Yes, so finally on the trust front, the BVI has always sought really to have a commercial and practical trust regime. One feature of that is the Vista Trust and the Firewall, both of which Henry has talked about, which are heavily used by investor clients. Another is the various provisions of Part 10 of the Trustee Act, which I think are quite unique in the offshore world and were originally designed in conjunction with leading London commercial lawyers. They've actually been around for a while. There's quite a few of them, and I can't take you through them all individually, but essentially the tasty smorgasbord you can see on the screen there together make it easier for a trustee to trade with third parties and banks, which we all know from experience can sometimes be otherwise a bit of a challenge. For example, the provisions give statutory protection to trusts and persons contracting with trustees. They allow trustees to accept a charge over the trust fund or to vary the trust fund for the protection of creditors. They allow creditors not to have to check that a trustee is not breaching the trust by having contracted, and so on. Of course, the trustee must still abide by its fiduciary duties when considering whether to exercise such a power, but a pure ability to do so is often very useful and makes third parties more willing to contract with a trustee. So I said they've been around for a while and they were introduced in 2004, but until now they were only available to trusts established after that date. Now, however, they're available to all BVI trusts whenever established. That concludes the trust part of the talk, and now we're going to discuss probate. So before I talk about resealing, I first wanted to sketch out the basic BVI probate process. And I find a lot of people sort of switch off at this point, but I would say this probably affects a lot more people than BVI trusts do, because it applies to every human shareholder of a BVI company. A BVI grant is basically a document of authority issued by the BVI court to an executor of a deceased person's estate. It is required before a registered agent can process the executor's request to transfer the shareholder's shares to his heirs. And without a grant, the shareholder's voting rights also cannot be exercised, which may cause issues in corporate decision-making. Subject to what I will say later about resealing, a BVI grant is required even if the shareholder's family has obtained a grant in another country. This is practically necessary because otherwise, how else can a BVI registered agent identify a foreign grant or a foreign will from a forgery? A BVI grant is also required whether or not the shareholder owned assets outright, and also if they owned assets via a nominee, although not a trustee, as I will go on to explain later. Trusts are one of the exemptions to obtaining probate. However, nomineeships, also known as bare trusts, cease on death, with the UBO's interest entering their estate. They are often confused with substantive trusts, which we were just talking about, which remove the settlor's control and ownership of the assets, and so therefore avoid probate, because both types are often headed declaration of trust. The easiest way to tell them apart is basically the length of the trust deed. If it is only a couple of pages and says something like, the trustee must follow the UBO's instructions over what to do with their BVI shares, then it is a nomineeship or bare trust. In that situation, if either the beneficiary or a sole trustee dies, you need to get BVI probate to be able to pass the beneficial or legal interest to the heirs or to appoint a new trustee. We do not generally therefore recommend bare trusts just for this reason. It is also finally not possible to avoid probate through pre-signing share transfers, signing letters of instruction, or putting instructions in the M&A, because all of these automatically cease on death. So how to get this BVI grant? Essentially, the process involves a paper application to the BVI probate registry. The applicant will need to swear various affidavits on different aspects, registry searches will need to be run, and adverts placed in BVI newspapers. The BVI does not have inheritance tax, but the court fee is dependent on the size of the BVI estate. Once ready, the bundle of application documents is submitted to the registry. We're currently seeing quicker response times than previously and would quote conservatively at the moment a wait time for a response of about 2 to 3 months. However, this is very variable and largely dependent on the complexity of the application, in particular, whether there is a BVI will. So having sketched out all that background, what is resealing? Although, as I said, no foreign grant is immediately enforceable in the BVI, and that includes even countries like the UK, the BVI registry will reseal or confirm grants from certain jurisdictions. Basically, they take the foreign grant and put some stamps over it to make it applicable for BVI assets also. To obtain this still involves a paper application process, but it involves, I would say, around a third fewer requirements than a full application, and probably takes about a third less time. Before this new legislation, one could only reseal grants from the UK, its dependent territories and crown dominions, and those Commonwealth countries that still have the Queen as its head of state. So if you're from somewhere like Australia and you've ever wondered what the monarchy does for you, there is your answer. Now, however, that list has been extended to essentially the common law countries of the world, basically those countries that were at some point under British colonial rule. The two biggest additions are probably the US and Hong Kong. If, however, you are listening from South America, continental Europe, PRC, etc., then grants from your country are still unlikely to be included, and you will continue to need a full grant. It is also not actually compulsory to go down the reseal route, even if you have or will have an applicable grant. It's not uncommon for clients to be in a hurry over their BVI company and tell me that to obtain a grant in their home country will take a long time. In that situation, some clients go for the full BVI process immediately without waiting to obtain a grant in their home jurisdiction. If you or your clients are likely to need the full process, but you're concerned about the time it will take, is there anything you can do? We've had questions about another new statute, the Administration of Small Estates Amendment Act, which does indeed offer a quicker route. However, that is only for estates worth less than 25,000 US and where the deceased died domiciled in the BVI. One way to speed things up for all clients, however, is the BVI will I mentioned before. Wherever the shareholder was from, a BVI will is easily understandable by the registry. So in our experience, they process your application more quickly. Furthermore, it means you can agree with your client who should apply now, during the shareholder's lifetime. Otherwise, the law of entitlement as to who should apply is decided by the shareholder's domicile jurisdiction, not the BVI. And many countries, perhaps in the Middle East and Asia, don't really have the concept of estate administrator or executor. They only have the concept of heirs and inheritance. To translate these concepts into BVI law can be very difficult. I saw an application from a very large and complex Middle Eastern family, for example, run to 17 affidavits. That could have been avoided with a BVI will. One downside of a will is that it must obey the succession law of the shareholder's domicile jurisdiction. If it infringes that jurisdiction's rules of forced heirship, or Sharia law perhaps for Middle Eastern clients, a disappointed beneficiary can challenge it. That issue, however, goes away for our second option, the substantive trust. A trust which takes away the settlor's ownership and control, therefore removes the asset from his estate, meaning no probate and no succession rules. And thus we return to the beginning where we started, back to trusts, and I hand over back to Henry.
Thank you very much, Matthew. Yeah, so I think that was a very useful summary of how you can expedite the process for getting a grant of probate or letters of administration in BVI if you need to. But just to underline the point that that requirement falls away altogether if you set up a substantive trust. And we just had a few questions about trusts on what I've spoken about, what we've spoken about earlier. So I'll just seek to answer a couple of those. One of them is, if a trust is already established, which includes some reserve powers that weren't permitted before they were validated, will they be validated by this amendment, or are there other actions required going forward? And I think just to answer that most simply is the actual so the new reserve powers legislation has retrospective effect, so that there's nothing that needs to be done. But also, it's not really, the law existed before for reserve power trusts, but the list that was expressly in the statute was more limited and more conservative, but it was a non-exhaustive list. So you could still have all forms of reserve power trusts away from a trustee. It's just they weren't expressly in the list. So there's no doubt as to the validity of historically of reserve power trusts, even before this legislation. We've been drafting reserve power trusts for many years, which have had powers reserved away from a trustee that were not in the express list, but it was not an exhaustive list. Now it is a much more exhaustive list, and the statutory presumption is expressly in the law. So it just makes the situation a lot more clear to understand, to give comfort to practitioners. But the actual availability of reserve power trusts has existed all the way through. So there's no need to do anything else for older trusts that do contain reserve power trusts. One question just about general asset protection features of BVI trusts, and I think that comes back to the fact that when you create a trust, the assets are transferred away from the settlor to the trustee. If you reserve extensive powers away from the trustee to the settlor, for example, case law in onshore courts has shown that those trusts may be more open to attack, or accusations of sham could be levied at them. So when considering the reserve powers, you do need to be very careful and try and ensure that all powers that are not with the trustee are expressly fiduciary if possible. But it all comes down to also the firewall provisions, because if a foreign judgment is obtained which seeks to access the trust assets, those foreign court orders will not be enforceable in BVI because of the firewall, which has been extended and modernized through this legislation. And the last question that I'm able to deal with today is about Vista trusts and how they can protect an investment in a startup, and that's obviously a fairly topical question. I think the question about asset protection, etc., applies to Vista trusts as it does to anything else. So if we're talking about potential attacks on the trust, the same analysis as I've just given would apply. But the thing is with Vista trusts is that there is express standalone legislation which what it really protects against, it protects against the trustees having to in any way intervene in the affairs of the underlying BVI company which will hold the investment in the startup. The trustee, notwithstanding their general common law duties that would apply to other trusts, where it's a Vista trust, they don't have those duties. They hold the shares of the BVI company on trust to retain and leave the management of the underlying BVI company that would hold the startup to the directors of that company. So that's where the protection is offered in that case, because otherwise the trustee might have duties to intervene to protect the ultimate value of the trust structure, which are disapplied through Vista. So so that's how that would work. So that thank you to everyone brings us to the end of our session this morning. We hope that was a useful application of the laws and running through how they have enhanced the offerings in BVI, both from the trust planning perspective and where trusts aren't created, where making a BVI will make the process of obtaining probate or letters of administration much more straightforward. If there are any other questions about any aspects of trust or estate planning, please do contact myself or Matthew. And we thank you very much for your time this morning, and hope you have a good day. Thank you very much.
Thank you. Bye-bye.